各位同事，我哋呢個呢就研。
Good morning, members. This is a subcommittee to look at the 6 orders made under Section 49(1)(a) of the IRO and Gazetted on the 2nd of October 2015. We have formed a quorum, so let's call the meeting to order. First of all, let's elect a chairman. Mr. Sin Chung Kai. Mr. Kenneth Leung. I second. So you're the only candidate. I accept. Thank you. Please invite the team from the administration to join us. Thank you.
呢個係佢哋答啦封信，咁就啱琴日先至下晝俾到我哋，咁所以
委員有未啊？佢哋有 table 咗。
呢封就 table。咁其實咧就啦就寫咗2封信俾佢哋，咁佢哋亦都2封信都答咗嘅。呢個咧就第2封信嗰個 reply。
我想委員睇睇台。
Members, please note that we've tabled a paper for you, CB bracket 1, 68/15 to 16 bracket 01. It's a reply from the Financial Services and the Treasury Bureau in relation to the ALA's correspondence. I would like to thank the government officials for your attendance. For the 6 orders made under Section 49(1)(a) of the Inland Revenue Ordinance and gazetted on the 2nd of October 2015, will Mr. Poon or Mr. Chiu be walking us through the paper? Thank you, Mr. Chairman. Members, good morning. Would like to invite members to consider the following. We have got 6 orders so as to implement the exchange of information relating to Texas orders that we have signed with the Kingdom of Denmark, Faroes, Greenland, Iceland, Kingdom of Norway, and Kingdom of Sweden. Let me first of all talk about our policies concerning the exchange of information. All along, our policy has been such that we try our best to sign or to conclude comprehensive agreements for avoidance of double taxation, that is CDTAs. We have exchange of information arrangements as well as avoidance of double taxation. So far, we have concluded 32 such comprehensive DTAs. We'll go all out to extend the network of such agreements. In some places, they have indicated their intention, that is, for the time being, they are not interested to conclude CDTAs with us, but they would like to make arrangements concerning the exchange of information, that is EOI. And then for the Organization for Economic Cooperation and Development, OECD, it has said that we must have both CDTA and also the TIEA. That is the exchange of information with our partners. In 2013, the Inland Revenue Amendment No. 2 Ordinance was enacted so as to enable Hong Kong coming into arrangements with other jurisdictions concerning TIEAs. But I just want to say that our focus, our priority is still to expand our network of CDTAs. For the 6 agreements, they have been concluded with the Nordic jurisdictions. We try to adopt the OECD model as much as possible. But of course, in accordance with the needs of Hong Kong or the local needs of the other jurisdictions, we have made certain modifications. But we'll do try our best to adhere to the OECD model. Regarding the tax types, for the Nordic jurisdictions, the TIEAs reflect those types of taxes that are relevant to their circumstances. And for such TIEAs, when compared with the CDTAs or other TIEAs that we've already concluded, they are more or less the same. We do have protection for taxpayers' privacy and confidentiality of the information exchanged. We have got the same mechanism. For the 6 orders, they will come into effect on the 4th of December 2015. We do hope that the orders can be approved so that when it comes to exchange of information, Hong Kong will have a closer relationship with the Nordic jurisdictions. And once again, we can send out the message to the international community that when it comes to transparency of tax and in relation to combating cross-boundary crime, we are not sparing any efforts. Thank you. Before I open the floor to members for questions, I just want to inform members that we've got the following papers. First of all, CB bracket 161/15 to 16, bracket 01, bracket 02, and bracket 03. They are the correspondences between the legal advisor and the administration. LA, anything to add at this moment? No? Administration, can you brief us on the content of your response? Yes. On the 5th of October, your legal advisor wrote to us, so let me go to our response to that letter. On the 7th of October, we have given our replies. First of all, for the 6 orders, or the 6 agreements, and how they compare with the OECD model, TIEA, we have come up with a comparison table to facilitate your comprehension of the differences between our TIEAs and the OECD model. As stated in the table and as stated in my opening remarks, we try our best to adhere to the OECD model. But then for the taxes covered, etc., as well as the jurisdictions involved, we have made certain modifications so as to make them relevant to their specific circumstances. And then another question was about the Faroes. Your legal advisor has raised the point that is in relation to the reference in English in relation to the agreement. The agreement itself refers to the Faroes. For the TIEA concerning Denmark, it refers to the Faroes Islands. And then your LA has also said that elsewhere in the law books of Hong Kong, we have also used another reference. Well, whenever we conclude such agreements with other jurisdictions, we will try as much as possible to refer to the text that our counterparts have submitted to us in relation to the official reference, because such will be the best reference material. Thank you. Next, Mr. James To Let me first of all ask a question about this reply concerning the Faroes. For your October 7th reply, you have said that in relation to the TIEAs concluded with the government of Faroes, the title should be the Faroes. And then, in relation to the TIEA with Denmark, the Danish government refers to the Faroes, that is, using another reference. We want to have certainty. For the TIEA signed with Denmark, is it merely a reference? Does it have any legal implications or applications? Mr. Chiu, I think you need to understand that in the case of the Kingdom of Denmark, they may want to say that they have jurisdiction over the Faroe Islands, but in fact the TIEA itself refers to the case of Denmark only, and for the Faroe Islands, they have their own jurisdiction. So it doesn't matter if they merely mention that the Faroes come under Denmark. So I want to know about the significance. For the TIEA concluded with Denmark, it is within the definition of Denmark. It is clear that the word Denmark doesn't include the Faroe Islands. So for the TIEAs referring to Denmark and the Faroes, I think the scope is very clear. The one concluded with Denmark, it includes Denmark only and not the Faroe Islands, and vice versa. Well, in fact, we have seen such a discrepancy, so-called, when you compare the TIEA of the Faroes and the TIEA of other jurisdictions. Well, to me, it means that there won't be a case of uncertainty unless we are saying that there are two Faroe Islands in Denmark, and then Denmark may want to include the Faroes A but not the Faroes B. If we don't believe that there are two Faroe Islands or two islands of a similar name, then as long as we have got one for the Faroes, then it will apply to the Faroes, and then the one with Denmark would not apply to the Faroes. Mr. Chairman, when it comes to arbitration, it is different. I don't know whether it is a typo or not, but in any event, it's up to the S4J to advise us on the certainty. I hope the DOJ will not come back to say that it will insist of having an additional E in the spelling. Now, for the government of the Faroes to say that the name should spell without an additional E, then we should adhere to that version. So I think I don't find any problems here. Can you tell us why we've got three different visions? And what about Greenland and the Faroes? I think they are within the jurisdiction of Denmark. Why is it that they are able to have their own TIEAs? So what are their constitutional positions? Would it be similar to SARG under the PRC?
Perhaps I will answer the first question to begin with. In different treaties or conventions, how come there are different in spelling of the Faroe Islands? I'm not in a position to answer. However, I have searched the official website of the New York Convention. There is a footnote saying that whether the New York Convention applies to Faroe Islands, and it mentioned an official notice of the government of Denmark. And on the official website of New York Convention, there is an additional E in Faroes Island, but I can't really explain that. And as to your second question, that is Greenland or the Faroe Islands, and in what capacity they have to enter agreements with Hong Kong. With the Nordic jurisdictions starting from 2007, a lot of the jurisdictions have entered into agreements with a lot of governments. The Faroe Islands and Greenland have entered into agreements separately. So for Denmark, it has its own, the Faroe Islands has their own, and Greenland also has her own. So that is in line with past practice. Well, if you have an international agreement experts who have looked into their constitution, say for example in the Ministry of Foreign Affairs of the CPG, if they say that well they have as they have the capacity to do so, or if you have an expert saying that yes they have the capacity to enter into agreement, that would be better, instead of saying that well that's what they've done in the past and we can go ahead with the same practice. I don't think that should be the way to proceed. Mr. Poon, let me say on the basis of what Mr. To said on the ratification procedure, is it that for say for example for Greenland, they will have a way to ratify it in their parliament? So what constitutional basis do they have to make the TIEA effective? Is the role of Denmark government or parliament, or the parliament of Greenland? So apart from the capacity, there is also the ratification. Mr. Chiu? I'm not an expert in this area, but I remember in the negotiation process, this issue has cropped up. I remember both sides have had something to say. In my recollection, the Denmark side explained to us that whether it's the Faroe Islands or Greenland, they are just both Denmark and Norway have declared sovereignty over these two places, but mainly it's Denmark. Denmark is a kingdom. Their sovereignty covers these two places. However, these two places have their own parliaments, and they have a high degree of autonomy. So they have the power to enter into international agreements, taking into account their own needs. And as Mr. Poon said, in relation to CDTAs and TIEAs, Greenland and the Faroe Islands have the autonomy to enter into such agreements, and the situation is similar to that in Hong Kong. Mr. Chiu said he's not an expert, but all I can say is that if you can maybe give us half a page from lawyers in the DOJ or someone you have commissioned, saying that you have these people have looked into it and they find everything to be in order, then I will accept that. But when you say that, well, we need to know about ratification, because we need to know when it will be ratified and when it will take effect. Say, for example, if Denmark asked how come Hong Kong can enter into an agreement, maybe they have an expert on Hong Kong. They know that we have the basic law, and they know that apart from foreign affairs or national defense, we have the power to enter into agreement, and they are satisfied with that before they enter into agreements with us. I don't want to make it difficult for Mr. Chiu because he's responsible for Inland Revenue, and he doesn't claim to be an expert. Perhaps you will talk to the Secretary for Justice. If Rimsky-Yuen said that they've looked into it, then we will accept that. Anyone else? Mr. To, anything else? Not on this point. So you have no problem with the 6 orders? No. And there is a CB bracket 168. And it says that this will not happen. That is in overseas tax examinations. So Article 6 of the model, OECD model agreement. When it comes to our exchange of information, how is it different from their examination? In relation to overseas tax examination, under Article 6 of the OECD Model Agreement, there is stipulation saying that it is allowed. According to the Model Agreement, a contracting party may allow representatives of the other contracting party to enter its territory to conduct tax examinations. And in the model examination and the attached supplementary information, the OECD made it clear that as to whether a contracting party will allow the other contracting party to enter its territory, then it lies exclusively in the hands of the requested party. So there is a flexibility in the model agreement. And as to whether individual agreements will incorporate this article, it depends on the negotiation of the parties. Well, with regards to Hong Kong, first of all, we won't go to an overseas place to conduct tax examinations. Similarly, we do not allow other tax jurisdictions to come to Hong Kong to conduct tax examinations. So we don't think it is necessary or appropriate to incorporate this article in our agreements. I know you won't do that, but what I mean was, what kind of examination is it? So they come to our territory, they use the mandatory power, or they just enter into the territory and they dress up as someone else, say as a visitor. And if it is a restaurant, they will count the number of chopsticks and the number of customers of, say, a Denmark company. So what is the purpose of Article 6? Will the mandatory power be invoked? Or it can be done without doing it? Or is it the case that we have to render assistance? Which type is it? I know it won't be incorporated, but it's something quite serious. That's why I need to know more. I think what Mr. To is trying to ask is, in the model agreement of the OECD, what is the scope of the power and the practice? Perhaps I would defer to Mr. Chiu. My understanding is that Article 6 does not appear in our agreements. And when it comes to overseas tax examinations, the examination is basically conducted by the local tax authority. It's just that the overseas tax officials will be present and ask questions. So the power of enforcement rests with the local authority. Well, OECD covers a lot of countries. So are there countries that have incorporated this article to enable tax examination? Is limited to this approach, or there are different ones? It's difficult for me to answer you. In Europe, especially in the European Union, they already have an arrangement, and I don't know much about their arrangements. So I can't answer you. Well, there's no urgency because we don't have it, so you can take your time. But if you have time, please give us more information. My next question is, well, we've been doing this for a number of years. Well, the exchange of information was something that hasn't been done for a very long time, and then when it finally came, it came like an avalanche, and we're required to do it. So, is there some pressure or some inkling that there will be a wave of action that we have to do it? So, where are we in this regard? Thank you, Mr. Toh, for your question. In relation to tax examinations abroad, we see very clearly that in the OECD model agreement, that they fully understand the sensitivity and where it lies. And in relation to different jurisdictions, it will have implications of how they enforce the tax law. So they've made it very clear that the decision lies with the requested party whether such examinations are allowed. Even with the article incorporated, it will be decided on a case-by-case basis as to whether it will be enforced. The requested party has all the power to decide whether to allow the examinations. And in order to protect Hong Kong taxpayers' privacy, we have some safeguard. We have put in some safeguards, and that's why we do not incorporate this article. Well, my question was, if it appears in the model agreement, then I will be quite worried about it, because since it appears in the model agreement, it's a sort of standard. So is it the case that not many countries have incorporated into this article into their agreement? So what's the trend? Are there any jurisdictions that have started making preparations to do it? We have a very low tax rate. So if there is pressure or a developing trend to incorporate this, then we will have to comply. And it will take time for Hong Kong to get used to it. Taxpayers here, country, companies. We have to be fair. We shouldn't be caught unprepared. So I'd like to have more information. It's not in our agreement, so there is no urgency. So you can take your time to gather some information to explain to us, so that at least we get a feel for it. Because it may take some discussion and take some time for the idea to be discussed in society.
This is not the first time that we have exchange of information. No, I'm talking about overseas, tax examinations abroad. Well, in fact, we have got over 32 TIEAs. When we agreed with the counterparts, we didn't find ourselves under a lot of pressure to include tax examinations abroad before they were willing to conclude the agreements. Now, if we haven't got such a policy, if they insist on having such a policy, what will happen? What will be included in a TIEA? Well, in the course of our discussion, we didn't find that they would like to insist on having tax examinations abroad. Of course, all around the world, there have been many TIEAs being concluded. It will be difficult for me to tell how many of them have got an article on tax examinations abroad. But then for the economies with which we have signed the TIEAs, irrespective of the scale, we haven't experienced any pressure of this sort. It will be best if you can carry out an analysis and advise us. Maybe 3 or 4 years ago, it was not fashionable to have exchange of information, and then suddenly things moved very swiftly. The officer in charge came, there was a dinner, and then we were threatened, saying that no one could survive without one. Now, for those with many tax types, if they have all included such a provision, then it will be better for us. Of course, we are not interested in initiating any tax examinations abroad, but once they have all got it, then they will turn their focus on us. So if it has become a trend, if you find that there are dozens of such having such a requirement, then it means that a trend has been formed. Well, in fact, to be frank, it's already in the model, so it must be something serious. But it doesn't matter. This is not an urgent issue. I would like to go through the details. For the policy itself, does any member have other questions? Now, let me finish off with 2 questions. Just now, Mr. James Toll referred to the matter concerning tax examinations abroad. It will be best if you intend to have another bill. Please do your homework. I think James Toll may want to ask questions again in the context of the automatic exchange of information. For the 6 countries involved, have we ever talked to them about the possibility of having a CDTA, or did they take the initiative to say that they would rather have a TIEA? Maybe Mr. Chiu can answer the question. It is the government's policy to prefer CDTAs. That is comprehensive double taxation, comprehensive agreements for avoidance of double taxation. But then for the 6 jurisdictions involved, they said that they did not have such an intention to have CDTAs. There was one that is in the course of having a CDTA with us, that is Finland. We have been able to convince Finland that CDTA is to be preferred to TIEA. So for the discussion with Finland, it will continue. But for the 6 jurisdictions, in the orders, we'll be having the TIEAs. Mr. Chairman, will continue to follow up to see if they would like to have a CDTA as well. We believe that once we have a better relationship with such jurisdictions, with the presence of a TIEA, I think if we want to take it further so as to have a CDTA, it will be helpful. Well, for the 6 orders, Mr. Poon, would you like to walk us through the provisions one by one, starting with the Kingdom of Denmark? Yes, I will start with the order concerning the Kingdom of Denmark. I'm sorry, maybe our legal advisor has got a question as well. Mr. Chairman, I understand that recently the Appeal Court of Bermuda has come up with a ruling, and it may be related to our discussion today. That is, the government of Bermuda has asked for a company to come up with tax information so as to hand it over to the requesting party. the information holder would like to have a look of the request so as to make sure that it is in line with the OECD model. But then the government of Bermuda has said that the content of the UI request cannot be shown to the information holder. The court ruling is that the requesting party must show part of the UI request to the information holder so as to establish that the request is already in line with the various legal requirements. In the case of sensitive information involved, it can be sort of blocked. The court has said that this is being decided on the basis of being fair and just. For 112BI, we have got section 5(1)(a) saying that before disclosure of information, the IRD must write to the information holder disclosing the nature of the information requested. It appears that we only need to disclose the nature of the information rather than the specific content of the UI request for the information holder. In the light of that precedent case of the appeal court in Bermuda, maybe the government would like to have a look. The government tries to answer the question in paper CB1 68/15-16(01), but I don't think the government has really considered that particular case, so I just want to draw members' attention to that. Thank you. Any comments? Yes, we have read that particular case when the government would like to get more information from a company involved. The company disputed the case, took the matter to the court, and asked for the entirety of the original UI request. For the court rulings of overseas jurisdictions, I think it will be difficult for us to pass a comment on it. But then, as stated in our response, we have followed the requirements of the OECD and would also like to give regard to the information holder's right to know. We would like to strike a balance between the two. If a jurisdiction would like to put a request to us and ask for exchange of information, the IRD may not have all the information requested, so we may need to approach the information holder or the relevant person or even a third party possessing such information to provide the information. In this case, the IRD would send out a notice to ask for the documents or the information. When the IRD makes such a request, naturally there will be disclosure about the scope of the UI request as well as a rough idea about the information they are looking for. According to the international standards or practices, it is silent on, or in fact, there is no requirement to show the original letter to the information holder, despite blocking out certain information. But in fact, there are very strict rules concerning confidentiality of the UI request. It is not just a matter of confidentiality about the information we put forward to the requesting party. We have also noted that in individual jurisdictions, when they have OECD tax-related forums and when they review the matter, a concern has been expressed. That is, when a tax jurisdiction is to ask for some information, maybe too much information, would have been disclosed to the information holder, and in fact this would jeopardize the international exchange of tax-related information. The requesting parties' ability would be jeopardized. The effectiveness of their work in making use of the information may be jeopardized. Therefore, we need to strike a balance. Any questions? Any more questions from the LA? Mr. James Toh, a question for the LA. Have you referred to that case from Bermuda? Yes, indeed. Please refer to paper CB bracket 161/15-16 bracket 03, second last paragraph. The Minister of Finance versus Bunch Limited. Which two countries are involved? Is it a English case? No, Bermuda. There is a country having concluded a TIEA with Bermuda. It was the government of the USA. So the US government requested the government of Bermuda to provide some information, and then the taxpayer, that is the enterprise called Bunch Limited, it took the case to the Court of Appeal and then asked for the government of Bermuda to disclose the information, right? Yes. It may not be right for me to comment on the court case, but in fact it was in relation to an agreement signed between Bermuda and Argentina. They also practice common law. It isn't a matter of whether it is right for you to comment on it. It is a matter of whether it is relevant, it is applicable, or whether you need to cite something more authoritative. Otherwise, the way I see it is that if you to rephrase what the legal advisor has said, maybe the requirement to be fair and just cannot be met. You have talked about striking a balance and confidentiality on both parties. Now, I think the court is exactly saying that the balance has been lost. If it can be extended to Hong Kong because it is common law jurisdiction, then we may have a case in which it is not an appropriate case. That is, you only disclose part of the information instead of full disclosure. And if necessary, you have redaction to block out some sensitive materials. So you need to answer this question from legal point of view. You can't avoid not commenting on it unless you say that it is not applicable. There aren't too many case laws, but it is developing.
Well, unless in our statute or in regulations there is a clear provision. Well, I do understand where Mr. Toh comes from. If there is a clear differentiation in the law as to what is to be shown to the taxpayer, of course, a statute will override common law provisions. But if you can tell us that that is in our statute, then it will be clearer. Mr. Poon or the DOJ, can you explain to us? Perhaps let me explain it this way. When the IRD makes a request for provision of information of the information holder so that we can fulfill our obligations, we do it in accordance with our law. The arrangement is clearly stated in our tax laws, and the implementation is also done according to the provisions. And you now say that there is this case. Well, we have to follow Hong Kong's laws. You can't just arbitrarily say that we will follow the laws of Hong Kong. But if it's interpreted under common law, then you will just redact it to exclude sensitive material. Just now, the chairman asked, can you tell us how the current legislation is worded? Is it different from this case? And if it's the same, then you point it out to say that, well, yes, it should be redacted to exclude sensitive material. I don't know if you have any information to reply to this question. I don't find your answer to the legal advisor's answer satisfactory. We have to look into it in detail. You can't just say that, well, we have our law and it's their own court case, and we don't care about them. You can't do that. Mr. Chiu, if you can, please answer. Let's look at it from a different perspective. The legal advisor mentioned about disclosure rules. It's absent in Bermuda. So when we implement exchange of information, we follow the disclosure rules, which sets out the procedure. As far as we understand, the Bermuda case is about judicial review. Well, Bermuda has their own common law, and we have our own, and we have statute law, that is the disclosure rules. So it's different. On a technical level, the IRD will have to follow closely the disclosure rules to implement the exchange of information to meet the statutory requirements. Perhaps you can give us a paper about the treaties or agreements that apply, and also what the disclosure rules are. And thirdly, that you think the case does not apply. It's just an analysis. And if I think that that is more or less the case, then yes, it doesn't apply. But if it does apply, will you follow the case to interpret the disclosure rules in its application? Just tell me your interpretation, your legal interpretation of the disclosure rules, whether it's interpreted after you've considered the case. There may be two ways. You can just ignore it until you've lost your own a case, if one should arise. Or secondly, then you don't want to undermine your position when it comes to future agreement, then you will legislate to say that this case doesn't apply. Just tell us your views, your inclination, and your policy. Please give us your paper after the meeting. I would like to ask, the disclosure rules, you're referring to our subleg? Yes. If your approach is that we have a very clear set of subleg and with clear wording, whether it's however you interpret it, is nothing to do with the case, you will have to state your view to convince members here that is not related, because we have clear statute and the interpretation is equally clear. If we find your explanation satisfactory, then that will be the end of it. Now we can go over the clause by clause, Mr. Poon? Perhaps you will point out the salient areas. Let's start with the Kingdom of Denmark. Well, the first section is the commencement, which is the 4th of December. The second section is the legal basis of the order, that is under section 49 bracket 1a. The declaration is made. Section 3, arrangements specified, is the agreement in relation to exchange of information agreement. You will find the provisions in the schedule. So is it very different from the blueprint? Well, these three sections are actually local legislation. So these three is not part of the actual agreement. Well, when we go to the actual schedule, then they are from the model law. Let's go into the schedule. There are 13 articles. The first one defines the object and scope of the agreement. The scope and objects is to provide assistance through exchange of information, and the information exchanged is in relation to the implementation, assessment and collection of such taxes, recovery and enforcement of tax claims, investigation or prosecution of tax matters that is foreseeably relevant, and the information shall be treated as confidential in the manner provided. And we have more or less adopted the wording in the model agreement. So it's very close to the model agreement. Any other questions in relation to the Denmark order? Well, we know the types of tax that are applicable. We only have a few. There is one on taxes on net wealth. How do we do it? Well, how will we benefit from it in this type of tax? In Article 3, tax is covered, and it's in relation to the types of tax that the exchange of information applies. So in Hong Kong, it's profits tax, salaries tax, and property tax. We can make a request, and in the case of Denmark, there will be taxes on income and capital gains, and taxes on net wealth that they can make a request. And as per our understanding and explained by Denmark, net wealth refers to taxes imposed on personal assets. So if a Danish person in Hong Kong, and if Denmark wants to calculate the net wealth of that individual, a request can be made to us, to the Danish person, or a person that holds the asset on behalf of the Danish person, and you will have to provide the information, right? Let me explain it this way. If a request is made by Denmark, and they will have to follow the disclosure rules stating why the request is made and what it's about, and what type of tax is related to. Clear explanation will have to be given to the Hong Kong side how the information is related to taxes on net wealth. I want to recap. Does it include your monetary power to ask all banks about the savings of a particular Danish individual. That's just an example. Do you have that power? Our experience is that we've never received a request asking for all the assets held by a person in Hong Kong. In general, the tax jurisdiction will specify a bank before we will find the information for them. We've never encountered a case when it's just a blanket. We're just talking about the law. Should there be some reasonable suspicion that a Danish person has opened an account in Hong Kong? It's just something that they don't know, so they ask you to ask all Hong Kong banks. And instead of a transfer made from a Danish bank to a Hong Kong bank. What if they say, well, we have suspicions that the money has reached a certain bank and then is dissipated into other banks, and so they ask you whether this person's name appears in any bank. Is it a case that they can make that request because of the agreement? Let me give you some supplementary information. When we discussed with exchange of information agreement with the 6 jurisdictions, we have attached our disclosure rules to them, so they are very clear about Hong Kong requirements. One point in the disclosure rules is that they have to point out which person owns or holds or controls the information they are seeking. In other words, they can't just without any good reason ask us to find all the information for them. So the particular person is very specific, right? Yes. Mr. Poon. Thank you. Do continue. So this is Article 2 is about the jurisdiction. That is, the requested party is not obliged to provide information which is neither held by its authorities nor in the possession or control of persons who are within its jurisdiction. And that is the same as in the Model Agreement, Article 3. Taxes to which this agreement applies. In the case of Hong Kong, 3 types: profits tax, salaries tax, and property tax. And in the case of Denmark, the types of tax set out. This reflects their tax regime. Please continue. Article 4. Definitions. Say, the Hong Kong Special Administrative Region, Denmark, company, competent authority, contracting party. The definitions are very similar to those in the Model Agreement. Article 5 then. Article 5 is about exchange of information upon request. In the case of Denmark, we have adopted the Model Agreement of the OECD. That is, when a request is made, the requested party is to follow it up in a certain way. And the only place where it's different from the model law is the addition of paragraph 5 to specifically say that where requested party shall disclose information that precedes the date on which the agreement has effect for taxes covered by the agreement. Insofar, the information is foreseeably relevant for a taxable period or taxable event following that date. So we will ask the requesting party to confirm and to prove why it's foreseeably relevant.
Paragraph 5嗰度
For Article 5, Paragraph 5, in the absence of such a provision, does it mean that they cannot ask for information prior to that date? Well, the disclosure rules have to be very clear. That is, generally speaking, information prior to the effective date should not be covered unless it is relevant, unless it is foreseeably relevant for a taxable period or taxable event following that date, and then that information can be disclosed. Say, for example, the date in the certificate of incorporation of a company may date back a long time ago, but then it may be relevant to the information requested. Mr. Poon, Article 7, confidentiality. This is to Mr. Poon. What about Article 6? You have skipped that. Oh, I'm sorry. Are you saying that for Article 5, Paragraph 6, small Roman E, grounds for believing that
requested party or is in the possession or control of a person within the jurisdiction of a requested party. 即係嗰個 control of a person 咧，你哋所理解咧
What is meant by control of a person is our understanding that they must have specific information as to which individual is relevant. Yes. Article 6, declining a request. So the requested party may not have to provide information upon request. The wording is the same as that in the model document of the OECD. Yes, please continue. Article 7, confidentiality. This is to make sure that information received from another contracting party will be protected. Information has to be treated as confidential, and it can only be disclosed to persons or authorities in the jurisdiction of the contracting party concerned with the assessment or collection of the enforcement or prosecution in respect of or determination of appeals in relation to the taxes covered. They shall only use such information for such purposes, and then they may not disclose it to other person or entity or authority or other jurisdiction without the express written consent of the competent authority of the requested party. I may want to raise this question in the context of the order concerning Greenland or Faroes. But I suppose that when you sign on the basis of the TIEA with Denmark, it means that you cannot forward the information to Faroes or Greenland. But what about information obtained from Greenland? Can it be forwarded to Denmark? Mr. Chiu, information obtained from a taxation jurisdiction cannot be forwarded to a third jurisdiction. Well, I'm sure they will be interested in asking this question. That is, they want to know whether information exchanged with Hong Kong will be forwarded to the mainland of China. No. It's only bilateral. It cannot be forwarded to a third jurisdiction. Mr. Chairman, a follow-up. In Hong Kong, there is nothing in law for the Beijing government to ask for information from the IRD. There isn't anything in the law to provide for that. Here we are talking about Denmark. What about the similar provision in the order concerning Faroes or the order concerning Greenland? Can we confirm that constitutionally speaking, the central government of Denmark will not be given such a power to get the information right? Who will answer the question? Every agreement signed by Hong Kong, whether it is CDTA or TIEA, we have made it very clear that the information cannot be forwarded to a third jurisdiction. This is because within the European Union members, they may exchange the information. They can forward the information to other EU members. But for us, we want to make things clear. We have made it clear that anything obtained cannot be forwarded to another EU member within the context of the CTA and the TIEA. Now, for Hong Kong, we practice one country, two systems. We are a separate taxation jurisdiction. Information we get will not be forwarded to Beijing and vice versa unless we have our own bilateral agreement for the purpose of exchange. Mr. James Toh, from the outset, has asked a question, and he would like to get the answer from the SJ concerning the matter of sovereignty. I think my question is equally relevant. Now you say that we are an independent taxation jurisdiction. I want to know whether Denmark can order the production of the information, and then they have to surrender, and then they have to forward the information. Are you saying that the agreement is a protective shield and then Faroes cannot submit the information to Denmark? Thank you, Mr. Chairman. Let me explain in this way. For the agreements that we have signed, they are bilateral, and the unit is that of a tax jurisdiction. So for information given to the Faroe Islands, whether it will be given to a third jurisdiction like Denmark. No, I am not talking about third jurisdiction. It's about the sovereign state. I don't think the UK can make an order, but what about the sovereign state? As I have said, the contracting parties are the tax jurisdictions. Say, for example, a hypothetical case. Say, for example, one of the contracting parties is to forward the information to a party outside the agreement, then our understanding is that it is a breach of the agreement. If it is found that someone has done this, I'm sure they will be jeopardized in terms of international cooperation on taxation matters. Now, for Article 7, confidentiality, I've just checked it. For the Faroes order, we have also got a similar article.
Person or entity or authority or any other jurisdiction without the express consent of the competent authority of the requested party. 嗱，我估阿潘生所講就係呢句啦，其實得呢句啫嘛。
I think that's the only sentence relevant.
如果佢究竟係唔係有，佢有得能夠同你簽訂同佢嘅所謂 jurisdiction？
No. When you talk about jurisdiction, you assume it to mean tax jurisdiction. But then for the Faroes Island, it hasn't got a court of final appeal. And all the judgments are such that the Danish judgments will apply to the Faroes Island as well. So it means that there is one single jurisdiction covering both the Faroes as well as the court of final, the appeal court in the Copenhagen. So they are not talking about giving it to another jurisdiction. Is there any definition for the word jurisdiction, Mr. Chairman? Let's go back to Article 4 regarding the term Denmark. As we have already pointed out, the term Denmark does not comprise the Faroe Islands. In other words, the two places have been excluded from the term Denmark. We can refine it. Article 4. Article 4 definitions 1A bracket small Roman 2. It talks about the Kingdom of Denmark and what areas will be included. At the end of the paragraph, it makes it clear that the term does not comprise the Faroe Islands and Greenland. The term Denmark doesn't include the Faroe Islands, but jurisdiction, unless you have got the jurisdiction of Denmark or the jurisdiction of the Faroe Islands. Is there a definition for jurisdiction? The fact is that we do not separately provide for the definition of jurisdiction, but as I have always said, for us to sign such agreements, and it is also the international understanding that it is something between tax jurisdictions. For Article 4, 1A2, and also Article 7, I'm not actually asking a question about this particular article, because for Denmark it doesn't include the Faroe Islands. But then I must apologize for jumping the queue, and I would like to talk about Article 7 of that Faroes order. So please make it easier to understand. So even if they have done something, we can tell them that this is how we interpreted the provision. So please try to have half a page space for this point. There are a few legal points here. The capacity of the Faroe Islands and Greenland to conclude such agreements, and then between Greenland and Denmark and between Faroes and Denmark, we want to know whether the domestic law would prevent the local government and the central government from exchange of information. I think that's the concern of James Toh and Sin Chung Kai. Yes, you may very well have written something here concerning the principles of exchange of information relating to taxes at the international level, but we are worried as to whether there is something like the relationship between Hong Kong and Beijing, so that we cannot exchange the tax information. Mr. Chairman, as Mr. Poon has said, generally speaking, for such tax agreements, the contracting parties are tax jurisdictions. So whenever we talk about jurisdictions, we talk about tax jurisdictions. I want to point out that for this TIEA, my understanding is that it will be regarded as an international agreement under international law. Now, there is a commonly accepted principle, that is, an international obligation will prevail over domestic law. But then there are two schools of thought, and your interpretation may not always be true. Sometimes you need to have an express provision. Others may not share your view. Now, for Article 7 of the Faroes Order, it says any other jurisdiction.
Tax itself is meaningless because there is no such thing as tax jurisdiction, because you're talking about tax imposed under the law. So if you define Faroe Islands, that includes landmass, territorial waters, of course, is the jurisdiction of the Faroes. And if the Faroes don't have their final court of final appeal, then they can't have the ultimate interpretation, because if they have that power, they may say that they have independence, so they are not allowed that power. So any other jurisdictions, then it may mean, well, for the case of Denmark, yes, then they have jurisdiction. The Faroe Islands might have entered into the agreement under the consent of Denmark, but sometimes it cannot be done. Well, we're clear about where the government comes from and what we're trying to get at, but it is not reflected here. Perhaps I can provide some information or analysis to you. Please continue. Then is Article 8. That is in relation to fees arrangement. Well, costs incurred in the cost of responding to a request, and how is or who or which side will bear it. It is all set out here clearly. Well, the ordinary costs, incidence of ordinary costs in the cost of responding to a request for information will be borne by the requested party, and it is in line with the model agreement. Well, have we charged fees from any other jurisdictions? Whereas only the one between Hong Kong and U.S. That is the only one, and the U.S. has not made any request, and the other 6 TIEAs are these 6. Article 9, implementation legislation, and it stipulates that contracting parties shall enact legislation necessary to comply with and give effect to the terms of agreement. Article 10 is language. Requests for assistance and answers thereto shall be drawn up in English. Please continue. Article 11 is about mutual agreement procedure. This stipulates that the competent authorities shall endeavor to resolve matters by mutual agreement. This is largely adopted from the model agreement. Article 12. Entry into force. Entry into force, yes. And it clearly states that contracting party shall notify the other in writing of the completion of the procedures required by its law for bringing into force this agreement, and the agreement shall enter into force on the date of the later of these notifications. And it also says that when the provisions of the agreement have come into effect, the taxable period beginning is also stipulated. And in Article 13 is termination. If a contracting party terminates the agreement, this is to be done in this way, and it's largely adopted from the OECD model law and also the CDTA provisions. Next, Mr. Poon, in order to save time, if this is similar to the Faroes Island, perhaps you just tell us where it's different. So in relation to the remaining 5 orders, the wordings are more or less the same. Where there are differences, and they will be like, say for example, in schedule, and in the schedule, Article 3, the types of taxes covered. And in relation to Hong Kong SAR, they're exactly the same. And for the other contracting party, well, because of the different tax jurisdictions and their own tax laws, the types of taxes may be different, but it reflects the tax regime of the other side. So it's Article 3(1)(b), and that will be the main area where there are differences. And it applies to all the orders, all the other orders. It's just a general question. Say the Faroe Islands, 1B. For me, there are some taxes that are quite strange to me. Say, for example, Hydrocarbon Tax Act, Tonnage Tax Act. Have you looked into these kinds of tax? Do you have any information? Because there is, because it's impossible for us to find the information for them. So have you taken into consideration feasibility and practicability? Hydrocarbon tax exists in a lot of Western countries. The layman term is green tax. Say, if there is carbon emission, you will have to pay tax. For tonnage, it's in relation to shipping. A lot of countries will impose tax on tonnage and not accounting profit. And you will find these 2 types of taxes in a lot of Western countries. I don't know if there is any a company of the Faroe Islands here. Well, do you have the power to ask questions relating to, say, their carbon footprint, and it's impossible for you to measure it? Well, a request is made in the negotiation, and we've explained to them that yes, it's there, but we can only provide the information if we have the information. If we don't even have the information, then we won't be able to provide it. Mr. Toll. For Denmark and here, or maybe other countries as well, there is except custom duties. Well, what particular reason is there? Because it's mentioned there. Which article? Article 3. Taxes covered. Say for Faroe Islands, B7. Other categories. But it specifically excludes customs duties. Any special reasons? Well, we've clearly stated in the negotiation that for our IR ordinance, it's mainly income tax. So for taxes that are outside the income tax, we basically won't be able to obtain the information. And so we told them about it, and they say, well, so these are just taken away. Well, have you explained to them that our income tax may be different from theirs? And they may have different types of taxes, bizarre ones even. But are they mostly? Do you agree to these the tax types if it's income in nature? Say, for example, Article B, say Roman 1, Roman 5, Roman 6, and inheritance tax and consumption tax. But we don't have customs duties. That's right. For consumption tax, of course we won't have the information. Then why did we agree to that? Mr. Chiu? For goods and services tax or consumption tax is a kind of turnover tax. For a lot of tax jurisdictions, in relation to goods and consumption and also service tax, it's tax-free. They may like to request for information is whether the goods and services is actually supplied to Hong Kong. Mr. Tong. Oh, basically, I think we should only include taxes that are present on both sides. Otherwise, it's strange to have, say, tonnage tax. I also find it strange. It's not just about the exchange of information. Other CDTAs as well. There are some tax types that are absent in Hong Kong. Is that right? Well, Hong Kong has a simple tax system, and we only have 3 types of direct tax. For other countries, there are many more different types. We've taken into the actual situation, and we will also consider whether there is an actual need for them to make the request before we decide whether to include them. Well, just some thoughts, food for thought for Mr. Poon. Say we have stamp duty, and stamp duty is not included in the 3 types of taxes. For B, they have included the miscellaneous types of taxes. And if, say, there is a company in Denmark or Faroe Islands, then why don't we include stamp duty? Is it done on purpose, or you think that it's already included in the 3 types? Well, for stamp duty, I know that we're talking about a substantial amount of money for even a single transaction. You may not know. So how come stamp duty is not included? Mr. Chiu? And there is a stamp duty in a lot of countries, and the spirit of stamp duty is tax imposed on an instrument. For Hong Kong, is mostly on the transfer or conveyance of immovable property or stocks and securities. And 99.9% is just Hong Kong people. So the chance of our having to ask of another jurisdiction is rather slim. Both sides agree that the chance of making such a request is quite low. So they don't even attempt to include stamp duty. That's why we don't. So you have looked into the other side and found that there are certain types that are not included. As far as we know, or from my recollection, there are a lot of tax types that are not included. So when you were talking about which type of tax is applicable, they have made you understand why they picked and choose certain ones. Yes, we've asked them to explain as well. In the OECD model agreement, in relation to bilateral agreements, and as to what types of taxes are to be included, they have given us, set down a framework. So no matter what name the tax is called, we follow the model agreement. I see that in the case of Denmark, they have provided taxes on immovable property, and we know that we have a large amount of taxes coming from that as well. Our property tax may be different. And maybe we are shortchanged as a result. Anything to add, Mr. Chiu? Well, when we're talking about types of taxes, we have considered whether there is an actual need. If there is, then we will consider their request before we will think about it, think twice before we incorporate it. If we don't even have the information, we will try to convince the other side to not include it.
Mr. Chairman, I'm sorry. Once it has been concluded, we need to reopen the negotiation if we want to make any changes. Now they have already included this item, taxes on immovable property. I don't know what it means. Maybe I would want to ask you to include taxes on immovable property as well, because it figures quite significantly in the case of Hong Kong. So, Mr. Chiu, I won't advise you to reopen the negotiation for those agreements already concluded, but for future agreements, please bear this point in mind. I don't know what exactly it means, taxes on immovable property. It doesn't harm if we include the same on our side. If you say that it is against the OECD, then they are also breaching the OECD requirement. Mr. Chiu. Thank you, Mr. Chairman. Our understanding is that we have to be very precise about the tax type. Profits tax, salaries tax, and property tax. Within our tax laws, they are clearly defined. Again, on their side, they are clear about the tax types. In Hong Kong, we call it property tax. Usually, they would call it taxes on immovable property. So, in fact, we are talking about the same thing. To me, taxes on immovable property, you are saying that in the case of Denmark, it won't include stamp duty. No, it won't. James, any other questions? No, I haven't got other questions. So I hope that the supplementary information will be given to us ASAP, in particular legal advice. Members, would you like to have any public hearing? No, I don't think so. I don't think the public would be too interested in the 6 orders. Now, let's take a look of the legislative timetable. The expiry of the scrutiny period is the 11th of November 2015. If we follow this timetable, then we have to report to the House Committee. Since we are waiting for supplementary information, why don't we extend the scrutiny period? Yes, we can have it extended until the 2nd of December 2015. And in that case, for us to report to the House Committee, it will be the 20th of November 2015. And then for the deadline for giving notice of motion to amend the subsidiary legislation, it will be the 25th of November 2015. Since we have to wait for some outstanding papers, so either on the 4th or the 11th of November 2015, I'll be moving a motion to extend the scrutiny period to the 2nd of December 2015, so as to enable the subcommittee to provide a report to the House Committee and to allow us to read the papers from the government. If members think that we need a further meeting after reading the papers, then we can have it on the 30th of October 2015 between 10:45 and 12:45. AOB? So meeting adjourned. Thank you. Thank you, Mr. Chairman. Thank you, members.